Ephesians 6:1. Children, obey your parents in the Lord, for this is right. Good day, everyone. This is Jaini D. Sumalpong from BTLED 1A of USTP Oroqueta. So for today, we will be talking about the Executive Order number 209, which is the Family Code of the Philippines. We will be focusing on the Title 9, which is the Parental Authority. I will be discussing Chapter 1, whereas my groupmates will discuss further. Chapter 1 is the General Provisions. In Article 209, pursuant to the natural right and duty of parents over the person and property of their unemancipated children, parental authority and responsibility shall include the caring for and rearing of such children for civic consciousness and efficiency and the development of their moral, mental, and physical character and well-being. This states that parents have the responsibility to take care of their children's until they grow, which whereas parents will teach children their moral, mental, and physical character for them to become well adults. In Article 210, parental authority and responsibility may not be renounced or transferred except in the cases authorized by law. This states that you cannot disregard children's, your responsibility. In Article 211, the father and the mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. It is clearly stated that if disagreement occurs, father's decision shall prevail. Children shall always observe respect and reverence toward their parents and are obliged to obey them as long as the children are under parental authority. This clearly states that children living on the same roof of their parents shall obey and respect their parents. In Article 212, in case of absence or death of either parent, the parent present shall continue exercising parental authority. The remarriage of the surviving parent shall not affect the parental authority over the children, unless the court appoints another person to the guardian of the person or property of the children. This stated that if one of the partner or the parents is deceased, the present parent shall continue to raise their children. If ever the present parent will be remarried, this would be effective to take care of his or her children. But there is an exemption. For example, if the present parent cannot continue to protect or to raise her or his children, then another guardian or person can be authorized. In Article 213, in case of separation of the parents, parental authority shall be exercised by the parent designated by the court. The court shall take into account in all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. No child under 7 years of age shall be separated from the mother, unless the court find compelling reasons to order otherwise. In Article 214, in case of death, absence, or unsuitability of parents, substitute parental authority shall be exercised by the surviving grandparent. In case several survive, the one designated by the court, taking into account the same consideration mentioned in the preceding article, shall exercise the authority. In Article 215, which is the preceding article, no descendant shall be compelled, in a criminal case, to testify against his parents and grandparents, except when such testimony is indispensable in a crime against the descendant or by one parent against the other.